Okay, let's take roll.
Commissioner Adaro, Commissioner Kasher,
Here.
Commissioner Hatch,
Here.
Commissioner Hayward,
Here.
Chair Remke.
Yes. Okay, good morning, everyone. We have a full agenda, so I'm going to get started right away, and I'm just going to remind everyone, as far as public comment goes, it's limited to 3 minutes per person, and with that, we'll start. Is there any public comment for an item not on the agenda? Okay, seeing none, then we'll move to item 2, which is approval of the April 2017 committee meeting minutes. Any questions or comments from the commissioners on the minutes? Is there a motion?
I move approval. Second.
Commissioner Kasher,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, so moving to the proposed consent calendar of enforcement matters, items 3 through 46. We'll start with, do the commissioners have any items they would like to take off consent due to a conflict or a need for voting separately? Okay, we'll start with Commissioner Hatch. There you go.
Thank you. Items, come on. My note taking is not perfect.
Should we start with Commissioner Kasher?
Yeah, thank you.
Go ahead, Commissioner Kasher.
Yes, I'd like to pull item 24 only for the purpose of my abstention. My law firm represents the County of Alameda. I've done work directly for the County of Alameda. This is a ballot measure for the county. And so for that reason, I'm going to abstain from voting on that one.
Okay, so you're not disqualifying yourself, you're just abstaining, correct?
That's correct.
Thank you. Commissioner Hayward, anything from you?
I have questions on the number, but I don't have anything I want to pull.
Okay, thank you. Commissioner Hatch.
All right. Sorry, I have a little technical difficulty here. I can't remember the 3 agenda. Item 44, I think it's 19 and 5.
Okay, so let's go in order. Item 5, the California Democratic Party. Is that correct?
Yes.
Item 19, you said? Which
Yes.
is yes on Prop 30.
30, yeah.
And then the last one you said is 44, Nancy McFadden. Are you just pulling them for a separate vote, or are you?
I'm pulling for a separate vote because in light of the communication we received yesterday that alleges issues with regard to all 3 of those in a conflict over the ownership of Lynn Energy stock. I personally have held Lynn Energy stock for quite some time, and about last year in April, I took the exchange offer to Linco. So I still hold those shares, and they're essentially worthless, I believe, by any reasonable interpretation right now. But I'm concerned about the appearance of a conflict. I did email Hyla about it.
Right. Commissioner Hatch emailed, and we did a conflicts analysis under the Act. There's no conflict under the Act, but just a possible abundance of caution appearance.
Yeah, I'd like, at least for the appearance, to.
So you'll be abstaining?
I technically, apparently, don't have a conflict. I would like to abstain on those items. That's why I asked them to be pulled off.
Okay, so you'll be abstaining on 5, 19, and 44, and Commissioner Kasher on 24. With that, we will go to the remainder of the consent calendar. And
Actually, excuse me, I also have to pull one. We're pulling item 16 from consideration.
okay, item 16 is pulled from the consent. It won't be voted on. Okay, with that, questions from the commissioners regarding the remaining items on consent. Commissioner Hayward,
Yes. Do you want to hear my list first, or shall I just?
why don't you just go in a
Just go.
numerical order?
All right. I'll
What's
do that.
the first one?
The first one is 3.
Okay.
In the matter of Michael Preston. My only question is that tantalizing first sentence of the stipulation. In 2015, proactive efforts by the Enforcement Division detected a pattern of activity that led to the opening of this case, which is like,
A good first
and then
sentence
you
book.
don't say. And I'm in suspense. What did we do?
Galena West, Chief of Enforcement. I actually periodically tout this program, so we don't repeat it in every stipulation. But I obviously haven't given them enough credit lately. If you're not familiar, so that's my fault. But the proactive efforts are run by our supervising special investigator Sandra Buckner. And what they do is they look at jurisdictions, especially ones with contribution limits, and we use our intern program in order to compile Excel spreadsheets of all the campaign statements in all the jurisdictions and look for patterns of behavior. And we have different patterns that we look for. We don't disclose all of them, so that way it doesn't become common knowledge. But they spend hours and hours pouring through different campaign statements of different jurisdictions to find patterns, identify things. Then it goes up to the senior investigator, and she then determines if there's enough there to bring it to me, and then we open a case and look into it. So it's a great program, and I'm really proud of it.
Thank you. That was my only question on that one.
Okay. Any other questions on item 3? Okay.
And the next one I have questions on is item 4. And I think here, because of the identity of the respondent, I'm just curious to know, is there any argument that a candidate's own money falls outside of the $5,000 reporting requirement? Or that there could be confusion on that point?
That's an interesting question. Actually, in the Act, it's defined under contributions to include loans, and it's never been a litigated issue as far as I know about personal funds, but the Act's been written very clearly to include them.
Okay.
I just had a quick question on that case as well. It does mention a prior for the respondents, and I just was curious what that was. I don't think it listed what the prior amount was or fine.
Sure. And as you know, ex-Chairman Schnur is familiar with the Act. But the prior that he has is a non-reporting gift on his SEIs several years ago. I think that was 2013. And then he has a professional treasurer named with him, Kelly Lawler of KIL, and she has multiple priors. She's had campaign violations, as most professional treasurers do. So we do mention it just to say it's a professional treasurer that has priors, but it's not taken as seriously as the candidate themselves having priors.
Okay.
I also have a question on that.
Okay, Commissioner Hatch.
In the stipulation, it mentions the use of a credit card, to pay expenses. Were you taking issue with the fact that it was never reimbursed, or you talk about all spending has to come out of the campaign account, but surely we don't mean that you can't use a credit card to make the actual purchase and then get reimbursed?
Yeah, it's a good question. Actually, we have procedures in place under the Act on how you can use a campaign credit card. So if you can't obtain one for your campaign, you can zero out a personal credit card and use it under the advice given in campaign manuals. And it gives you the procedures on how to do that. In this case, it was not that simple, where he was just making expenditures without telling the treasurer, using his own credit card. And so our issue is when you aren't putting it through the one bank account, then it doesn't keep the level playing field so everybody knows what the expenditures and contributions are for that committee.
Right. I know you can't rent a car without a credit card, and a lot of smaller committees, like city council or worship school board or something, they can't get a credit card for a campaign committee.
Right.
So there must be some accommodation there, and that's the zeroing out of a personal card. Is that what you're
Correct.
saying? You just pay it off.
Yeah,
and then
the
use it
commission
only?
has worked, and Hyla probably could talk more about this, but they've worked over the years to come up with accommodations so that the rules aren't impossible to follow.
Okay, thank you.
Okay, any other questions on item 4? Okay. Further questions regarding the items on consent?
Yeah, my next one, I wasn't sure, are we going to be talking about 5, 19, and 44 separately?
Yes.
Okay, then I'll leave my questions about 5 for that time.
Okay.
And I guess I have sort of a comment that I'm going to put in the form of a question to make it in order. Number 6, which is just that it seems like, as was articulated last month by a member of the public, and I think in general, something I can understand is the very material distinction between what is a yard sign and what is another kind of thing. Because if it's a yard sign, you don't put the disclaimer on it until you buy 200 of them. And if it's another kind of thing, disclaim every single darn one of them. And I just, and the STIP says that we've been clear and consistent with our advice, but have never been asked for formal written advice on the subject, although that's available. I think this just screams for a reg. Because, the individual advice you give people, even though, yes, we live in a world with a set number of players who are repeat players, and you can kind of figure that the word gets out. That's not really a great way of running a regulatory enterprise, I think. So I'm just, that's not a question, and it's probably out of order, but it seems like this area is
I think
maybe the question is,
I think it's a fair
statement.
I think it's a fair statement, and I think it's on legal's list of areas to look into and try to propose something that's
That's right. We were just adding it to our fact sheet, which is often the first place, a little more guidance, but a regulation is probably even better.
Yeah. Because I think this just seems like one of those areas where we're starting to develop sort of a secret common law of sign disclaimers, and that's not great. So, and we all agree that. So I'll move on.
Any from the commissioners, any other comments on item 6? Okay. Another question from the commissioners regarding the remaining consent calendar.
My next question is on item 9, and trying to sort of figure out what went wrong. This doesn't seem to be a very big committee. The reporting gaps are pretty large. I get the feeling, and correct me if I'm wrong, I know on the expenditure side, the thing that was failed to have been reported was, I think, a transfer to its national organization. When the failure to and what they say is unintentional failure to report of contributions, were those similarly kind of internal transfers, or were they more what you think of as a typical contribution where somebody writes a check for the organization and gives it to them from outside?
Galena West, Chief of Enforcement. This is one of those cases where I can speak more about the facts, because these are FTB audit reports, which are public documents. And it is a case where it's more contributions in the traditional sense of the word. And then, as is written in the stipulation, they had multiple other findings from the FTB audit. And so what we tried to do here, this is each audit report had a 2-year period, which is about a $250,000 of activity. So what we tried to do is, instead of giving a bunch of little violations, we try to group them together and say, okay, yes, there were transfers to the national organization, but also contributions that weren't reported in the traditional sense.
Okay, so perfect. That answers my question.
Any other questions from the commissioners on item 9?
I likewise had a question in my mind about the transfers to the parent organization. Are those required to be reported just like a campaign expenditure or contribution, this upstreaming of funds that may or may not relate to the campaign?
Yeah, anytime, and the whole reason the act's set up this way is so that way if you have a PAC and you have a national organization, then anything going in and out of that bubble is reported, because then that's the part that's campaign activity. So whether that be a transfer, I don't know if Isla wants to say it more eloquently, but I say bubble.
Okay. Okay, thank you.
Okay. Any additional questions from the commissioners on the remaining items on consent?
My next one is item 15. And I'm just, this one just seemed like it involved activity that was long enough ago. I'm wondering why it hadn't been resolved before. I'm not saying it's not too old. It's just kind of old. Was there an involved process in getting these people to the table? Can you give me a little sense for that?
Let me make sure. So let me check the summary real quick before I respond. It wasn't on it. Yeah. So when they're based on an FTB audit, sometimes they take a little longer to get to us.
Okay.
And because, as you know, Franchise Tax Board is very understaffed when it comes to their political reform division. And so we're always putting in a word for them to get more funding and more staffing. But so that causes a delay sometimes. And then we try to encompass violations up into the current period in order to try to keep it fair to the committee as well.
Okay. That's interesting. I think maybe this may be the first agenda where we've had audits, is it? Since I've in my long 3-meeting tenure now. So no, that's very, very helpful. Thank you.
And I do think there is a big concern with funding for FTB and their ability to even satisfy their mandate on audits. So that is something that needs to be discussed, and hopefully the legislature can see that they need to be properly funded in order to satisfy it, because I don't believe they're capable right now with their limited funding.
And they're statutorily required to do these audits.
And therefore, a delay.
Got it.
Okay. Next question on consent items.
Well, the only one I have is, and this isn't really a question, it's a typo. But since it's on consent, I felt like it should be pointed out before we voted on the consent calendar.
I think there are 2 typos actually, but go ahead.
But this is the one on item number 46, the 3rd page where it says description of violation. Even though we are fining them a total penalty of $100, the penalty box says 0.
It does.
And
We
I just
will-
want to make sure that, if there wasn't some,
That was noted, so thank you, and we'll correct that. I'll initial it before I sign it.
Okay.
There was another, which one number was that I
was,
pointed out
Mount
earlier?
Pleasant. I don't know what number that is.
There was another one.
Oh, yeah, 14. It says that the amount of the penalty on page 2 of the stipulation is $16,000, but it's written out as $21,000.
So it will be the 16,000. We'll cross out the 21,000 and initial it before it's finalized.
Right. And we always notify the other side since these are agreed upon resolutions.
Yeah.
Okay, any other questions on the remaining consent items from the commissioners? Let me just make sure I don't have any. Okay, hearing none, any public comment on the remaining items on consent? Okay, seeing none, is there a motion?
Okay, I'll move the consent calendar items 3 through 46 with the exceptions of items 5, 16, 19, 24, and 44.
A second.
Commissioner Kasher,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
yes.
Chair Remke.
Yes.
This motion passes.
Okay, thank you. Now we'll take each item individually that was pulled, starting with item 5. Any questions for those commissioners remaining?
I have a question. It's probably my lack of familiarity with the check inscription rule. I mean, it says that, you know, the correct words weren't on the checks, but then they had a stamp, and it's not clear that you have to have the pre-printed checks with the word. What was wrong with the checks? I'm sorry.
Okay. Yeah, I'm sorry about this case. It's very technical. And so I wrote it myself to try and give it to you in a way that was palatable. But so basically the requirement is the check has to be identified. If the check is identified, that's considered in compliant with the regulation. So their process, instead of having the checks pre-printed with the correct accounts, account number, account name, what their process was to stamp them and say, oh, this check's for all purpose, this check's for restricted, which would be fine if it happened all the time. So in this case,
was that two different accounts though, even though they didn't, so they had two checkbooks basically, but neither were pre-printed, and then they just were hopeful to stamp the right one on the right one at the right time.
right. So in this case, two checks were not stamped
With anything.
with anything.
Did they go into and they did not go into the right account
Well,
either.
they go to the person they're making the contribution to, the committee they're making the contribution
they
to.
didn't
And
know,
so then
that's
they're not
why. That's right.
identified to that committee as to what type of funds they are and what they can be used for. And so, which is one of the three parts of this. So then on a contribution that came in, two contributions that came in, they deposited them into the wrong account and then transferred them back out. So as they say in their mitigation, they performed an internal audit and they're no longer stamping and labeling. They are following the procedure suggested by the regulation and have cleaned up their processes.
Okay, thank you.
Any public comment on item 5? I will note that there is the letter from Consumer Watchdog, which goes to 519 and 44. So that has been posted online, and the commissioners have all reviewed that as far as public comment. Okay, seeing none, is there a motion on item 5?
I move approval of item 5.
I second.
Commissioner Kasher,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, we'll move to item 19, which is yes on Prop 30. I have a question on this. But for the amount we're talking about, which was a considerable amount, would this have normally qualified for streamline?
Correct. The $5,000 reports and all 24-hour reports, if they meet the streamline criteria, would be considered for streamline first. But the contribution of 1.5 million obviously kicked it out of streamline.
Okay, but otherwise the timing, the issue, the violation itself would have been streamlined. It was just the amount was so large.
Correct. And this was from a franchise tax board audit as well. And they were substantially compliant with everything else. In fact, there were no other material findings.
Okay, any other questions from commissioners on item 19? Any public comment on item 19? Okay, seeing none, is there a motion?
I'll move it.
Second.
Commissioner Kasher,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, we will move to item 24, which Commissioner Kasher is abstaining from. Any questions or comments from the commissioners on this item? Any public comment on item 24? Okay, seeing none, is there a motion?
I'll move it too.
I'll second.
Commissioner Hatch,
Aye.
Commissioner Hayward,
Aye.
Chair Remke.
Yes.
This motion passes.
Excuse me. Okay, item 44. Any questions or comments from the commissioners? Any public comment on item 44? Seeing none, is there a motion?
I'll move item 44.
Second.
Commissioner Kasher,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, so that does it for the enforcement matters. Thank you, Ms. West.
Did you want us to stay up for the next item?
Are you handling it or Mr. Bainbridge?
Mr. Bainbridge.
Okay, so the next item is item 47, motion to set aside default decision and order. Is Mr. Gao present? Okay, just wanted to clarify that in case there were questions for Mr. Gao. As noted, the commission approved a default decision and order in March on a consent calendar 4-0. Mr. Gao has made a motion to vacate that default decision, and that motion is what's before us. The Enforcement Division filed a response, which is part of the public record. And the remaining, do the commissioners have any questions or comments or discussion for this? We have both Dave Bainbridge, who filed the response, and obviously Legal Division can answer any questions.
I have a question.
Okay, Commissioner Hatch.
My question goes to what if we were to approve this motion to vacate? Has enforcement had sufficient interaction with Mr. Gao to indicate that you could, reach a stipulated arrangement on this one, or do you think it would be a clash?
We haven't heard from him at all. The only thing we've received is this letter.
Oh, I see. There's been no conversations or.
Has he not? Yeah.
Sorry, this is Dave Bainbridge. I'm the Assistant Chief of the Enforcement Division.
Mr. Bainbridge, so you said you have not had any contact with him, so he's not reached out to you. In his motion, he states, I believe, that, I want to be accurate here, all filings are, he says completed, but I think he means completed when you receive this letter. I also sent the cashier's check. Were you able to verify whether or not all filings were completed and a cashier's check was sent, which I'm not sure which.
Yeah, so I assume the cashier's check means for the $50 fee. We did receive a check for $400, which without any instruction as to what it would cover. I assume that would be for the 4 years of the $50 fee. It didn't include payment for the $150 penalty that would also be owed.
So even at that minimum, $150, but $200 a year, 4 years, $800 is what he owes on just that fee.
No, it'd be another $600 because there's 4 years of not paying the $50 fee.
Yeah, so
he's paid
$200
$400
a year. Oh, okay. I meant total, $800.
Yeah. Oh, okay. Yeah.
So
Let's talk
what
math.
was his total obligation on this? The $50 a year that's $200, right?
Yeah.
Plus, would the penalty be $200 for each one of those?
No, so it's 50 plus the 150, so 200 total a year.
Total $200. Okay.
Just to come current with what his obligation was. But again, I'm more concerned, as we always are in these cases, the statement that he completed all filings, because the initial issue is, and the reason the violations were found, which are more serious, I find, is that he did not do I believe they're semi-annual reports.
Yeah, he's filed, or the committee has filed 2 of the 3 that are mentioned in the default. The third one hasn't been filed yet. What we found in looking, they were filed on April 3rd and 4th. So the statement for the second half of 2015 showed about $3,800 in contributions and about $3,500 in expenditures. The statement for the first half of 2016 showed $14,200 in contributions and about $11,800 in expenditures. The statement that hasn't been filed yet, which is included in the default, is the statement for the first half of 2015.
So wait, that last one was 2016?
Yeah, first half of 2016.
And that was 14,000 in contributions?
And 11,800 in
So
expenditures.
this is still an active committee?
Yes.
Okay. Okay. Any other questions from the commissioners regarding the motion to vacate the default?
Yeah, I think this default was on, I think, my first agenda. And the thing that concerned me about it a bit was that it didn't seem to me like we actually effectively reached him until the very end of the process. We had been trying to reach him in San Gabriel at an address that, if you look it up, doesn't seem to have a connection to him, though I'm guessing historically it did. We didn't make up the address, obviously. It came from somewhere. And then we found him in Cerritos and successfully apparently got the material to him, which, yay. But I feel like, sometimes measures that would seem perfectly adequate to reach me aren't adequate to reach some other people. And I guess I'm sort of inclined to give him the benefit of the doubt and another stab at trying to come right with us, because I feel like in this case we may have been. I think we were missing him. I mean, we tried an awful lot, and but I think we were still missing him.
I would just mention that the address that we used until the end was the address on record with SOS for the committee.
I understand that, but it's apparently not his, or anymore it isn't.
But he's the committee treasurer, correct?
Correct.
With the responsibility of updating the address.
Not arguing that at all.
Yeah, no, I know. I just want to be clear. So, okay. So you're concerned. Okay, so you're saying.
I'm saying I would like to vacate the default and.
Any other
Grant his
questions or comments from the commissioners?
I had some concerns, and I would like to, if it's all right, to go over what our options are here. Either approve this or not approve it. Is there like a third or fourth course?
It'd be good if there were, right?
Yeah. I mean, I hate to put it all back on the table for him.
Well, right, but that's
actually, I would like to explore reducing the fine, but it sounds like we couldn't do that without approving this.
Yeah,
motion.
the options are to approve the motion to vacate the default or not, and approving the motion sends it back for an administrative hearing or resolution by stipulation. Correct.
And if he can't resolve it and
default.
he doesn't participate, we'll be back at a default again.
Yeah, that's possible. Yeah.
So unfortunately, there's no option to play with the decision.
Yeah,
Once we grant it, it's set aside and we're back to square one.
And I don't know, Dave Bainbridge, I don't know if we could put a default forward again, because the process is if they don't respond to the notice of defense, you can then issue a default. In this instance, I think we're moving right to the step where we're scheduling a hearing. So I think what would have to happen is we'd have to go, essentially, if he doesn't show up for the hearing, we'd have to do a prove up at the hearing of all the evidence, put on the evidence, get a decision by an ALJ, and then bring it back to the commission.
You could look into that. I think if he hasn't formally filed a response, but I won't talk on it legally. So, but we know that the decision would be set aside and we'd be back to trying to reach a resolution fresh. Okay. Is there
one further clarification? Sure. The thing that he responded to, was that at a different address than his previous communications?
It was sent to.
I'm just trying to understand why he just suddenly popped up here after,
Sure. We sent it to what we believe is his residential address. We had been sending communications to the committee's address, which is, I think it's an insurance office or something. Mm-hmm. But we also then emailed it to an email address we had also been emailing him over the course of the case. So I don't know whether he received it in the mail or through email.
But the one thing that was unique was the home address?
The home address we had used to serve him with the accusation. So it's the second time we
used that address. Okay. So it wasn't the first. Okay. Thank you.
And the accusation was served back in November 2016.
Yeah.
Okay.
Yeah, more than enough time.
Okay. To the commissioners, is there a motion on item 47?
I'll move to, are we granting his motion or vacating?
You just would be granting the motion
Okay.
to set aside the default. So you'd be moving to approve the motion.
Yes, I wasn't sure how that should be styled, but I would move to approve Victor Gao's motion to vacate the default judgment entered in March.
Is there a second?
I'll give you a second.
Commissioner Kasher,
No.
Commissioner Hatch,
No.
Commissioner Hayward,
Yes.
Chair Remke.
No.
This motion does not pass.
Okay. So do we formally have to move to reject it? Reject the motion? We move to approve it, which was denied.
I think that's
Sufficient.
Yeah,
so
that's sufficient.
by all means, we
his motion to
reject
vacate
it.
is denied.
Okay. Just want to be clear. The record's clear that it's been denied. Okay. So the next two items, thank you, Mr. Bainbridge, are items 48 and 49, which are closed session items, and they are properly listed on the agenda as to why. And so we will go off the record and go into closed session, and then we will come back on the record once we're done. Thank you.
Oh, I see we're leaving.
Why isn't your website? Oh, it's in the, it's now your one curious thing.
My mistake.
I gotta go.
Trying to crunch the last separate pages.
I'll get one back. But I will come back, the next
You
year.
got the big old stack.
I remember that, although it's just.
Very thorough. Sounds good. Yeah, right. Get one finger on that corner. Sorry, my son plays baseball. I've been watching a lot of baseball lately. Oh, thanks. Yeah. No, I would. I would like to kind of work with problems. Doing all I'm going to do it. I'm gonna run a little bit late here, so I don't want to shortchange it. A little bit. Yeah, well, it's your phone calling, so the system for that's another. Nice to meet you too. All right, we'll talk to you soon. Thanks.
It's that's right. Yeah.
Oh, wait, there's one thing I forgot.
Yeah. What a big news. Yeah. Let's tell us what we need to do. Yeah.
Need to ask him.
Yeah.
Because now that he's put that together, all the things to do. Her, put it together. That's what he was supposed to do. Assistant.
Okay, we'll go back on the record, and I will just report out on the closed session. As for item 48, the commission will appeal the Superior Court's order granting the motion for attorney's fees in the Burgess matter. As for item 49, the commission adopts the proposed ALJ decision with a reduction in penalty by $10,000 due to the dismissal of counts 2 and 4 and modifies count 6 to reference only Tony Novella. And there'll be an order issued to that effect. Okay, so that's the closed sessions. And last item, executive staff reports. Any questions or comments from the commissioners on that report?
This is Commissioner Casher. Just wanted to mention that I attended the League of California Cities City Attorneys Conference, and Jack and Suki presented at that conference to hundreds of city attorneys from around the state. So just wanted to mention it's always nice to see staff out in the regulated community. They did a great job with the presentation. So wanted to thank you guys for that.
Yes, thank you. Anything else? I would just like to close today's session with the sad news of the departure of our general counsel, Hyla Wagner. As many of you know, this is going to be Hyla's last commission meeting. And she's been with the commission since 1995. And before that, she was actually in this similar field for the New York City Campaign Finance Board. And as everyone who knows and has worked with Hyla, she is clearly an expert in this area. She's been invaluable to the commission as a whole over these years. And to me as a chair, I really rely on Hyla, and she does a great service for this commission, and I'm going to miss her very much, but she'll be moving to the Bay Area to start a new life, doing something.
Oh, thank you so much. It's been a great pleasure to work with you and with the commissioners and with the whole team here at the FPPC. The Political Reform Act, there's never a dull moment. It's always it's very interesting.
Well, thank you.
I'll just say, wanted to thank you for all your work on behalf of the commission, and thanks for being so patient with me with all of my questions over the years. It's been a pleasure working with you, and you're closer to me over in the Bay Area, so I hope we'll have a chance to connect that way.
Thank you.
Yeah.
I just chime in that I really appreciate your helping me and mentoring me in these last couple of months, because I was pretty raw and didn't have a very good feel for what I needed to do. Thank you.
Oh, thank you.
Okay, with that, I would move to adjourn.
Second.
Commissioner Casher,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes,
This motion passes.
thank you.